All right, in this show, we've got the exciting return of none other than David Pierce, UK patent attorney, for part three of a discussion. And stay tuned to the end of this video because we're going to go ahead and break down some really tough questions. And if you're a supporter of BSV, there are going to be some tough questions here, which may be a hard pill to swallow that David Pierce may be revealing. So just forewarning. But it's important to note that no matter what side you're on, that you face the worst case scenario by facing our fears. So whatever the fear is that you're having, let's say you're on, if you're supporting BSV and you have a fear, it's important to know what the worst fear could possibly be of an outcome of, let's say, or you're supporting Craig Wright. What's the worst case scenario? Let's face those fears. And today I think will be a great opportunity to do that. So you're definitely going to talk today about the Craig Wright appeal, COPA versus Craig Wright appeal case, and also the nChain patent portfolio. He'll bring up the case that he's already won on stipulation. There's a couple other ones that are going to hearing, it sounds like. But I have some really tough questions for him that are going to shed light on potential future strategies for COPA that he may be privy to. And so definitely looking forward to hearing about it. So stay to the end. We'll see you at the top. Be sure to subscribe at the like button, share the video, leave a comment. I want to hear what you have to say. And hey, looking forward to it. All right. So see you at the top. Okay, back on here with David Pierce, my friend. Good to see you. How you doing, buddy?
I'm doing good, thanks. Doing good. I've got yeah. I mentioned before we started that the background is a bit of a joke, but I'm borrowing Jack Mallers' closet for this conversation.
Nice. Yeah, I love it. That's great. It almost looks real. It almost looks like it's so close to looking real. I can barely tell it's CGI. It's like
Well, maybe we shouldn't have said.
I'm
People
kidding.
might think, where's Jack Mallers based? I think he's where you are
Yeah.
in I could have said I've flown over and borrowed his closet.
Yeah. So
Craig,
so in this video we got a part three here, and a lot's happened in the since we talked last time with the Craig Wright case, also with the patents that you're involved in. And so I just want to set the framework. The two subjects that I'm really interested in hearing, and also hear what you have to say, is like the nChain patents, the cases you have going on, and your theory on that stuff, and then also what your theory on the Craig Wright stuff. He's got the appeal, and I want to talk about worst case scenario situations, so as well. So yeah, why don't we just start with the big one, which is the Craig Wright case? I mean, what can you tell us about what you've been following on that?
well, nobody outside of the parties to the case have seen the what Craig's filed. We know that has filed something. It was a bit uncertain for that week after the final deadline whether he had actually filed something or if anyone knew whether he filed something. But it turned out this thing popped up. I haven't seen, but it's a 561 page appeal or application for permission to appeal. That's the correct wording. Where he is now, he has to could have applied to the High Court, to Justice Mehl, for application for permission to appeal, but he went straight to the Court of Appeal to ask their permission to appeal the judgment. So he filed that. Turned out one first thing is my suspicions when there was no sign of the developers and COPA saying within that 7-day period that they have to be served on any appeal that's been filed. My suspicion was that one, he'd either, and I mentioned this on X, one, that he'd either not filed an appeal, or second, that an appeal had been filed, but that he'd done it himself. And turns out that the second one is what's happened. So Craig Wright filed the appeal himself, so he's representing himself. Filed a huge pile of documents, which is at least, I would say, probably 10 times bigger than any normal appeal filing. So why that is, what the contents are, I don't know. But from what I do know secondhand, it's full of absolute nonsense, full of arguments that just let's say, are mostly irrelevant to the appeal. And Craig Wright has actually posted one page out of this 561-page document that goes into some detail about Marty Malmy doing something naughty about restricting Satoshi's access from whenever it was, 2010-ish. And immediately you think, well, take a step back and think, well, how is that in any way relevant to the appeal? It's not. It's just not relevant. You're making an accusation to someone who was a witness in the case.
Tribal
Can't
issue.
possibly have any relevance to the, well, one, whether you're going to get permission to appeal, and two, whether you've got any grounds for an appeal if it does get permission.
Yeah,
So,
I mean, and the first things first is he needs, well, obviously in an appeal, at least in the States, you file that notice, and then you got to get through that period where, okay, you qualify, you're accepted, you get through the acceptance period. And from my experience, that's not about argument in any way. In fact, there's no argument in that preliminary portion. That's how it works out here. Is that similar to this in the UK?
well, the basic test for whether you're allowed permission to appeal is there has to be a real prospect of success. So that's the wording in the practice directions in the civil procedure rules. So and that's generally termed to be more than a fanciful prospect. And if you remember the Bitcoin, it was the Bitcoin file format case that went to appeal because it was an issue about serving out a jurisdiction. So to be able to serve out a jurisdiction, there has to be the same sort of test has to be met, real prospect of success. So early last year, Justice Mehl ruled that there wasn't a real prospect of success. So that bit of the case had to be struck out. And then Craig Wright went up to the Court of Appeal and said, no, there was a real prospect of success. And Richard Arnold in the Court of Appeal and two other judges, but Richard Arnold took the main judgment, said, no, there was a prospect of success because there was a complicated issue about whether copyright was fixed in some way. So he's already been through that sort of test. And in that case, there was an argument. So that's the sort of base level that you have to get over. There has to be a reasonable argument that you could discuss, that a judge could rule on. If there's nothing arguable there, then you're not going to get this permission to appeal. So that's the question. I mean, the question is what possible grounds could there be? So there has to be some on the application for permission to appeal. There has to be some arguments in there because you have to show that there is a case. The judge doesn't have to rule on whether that case is going to win or not. The judge just has to go and look at it and go, is there something arguable there that I could feasibly hear in court?
What's the likelihood of success of this argument, basically?
Well, it's impossible to say without seeing the arguments that he's put, but I can't really see anything that you could possibly argue because the judgment was really only on one thing, which was the identity issue. So whether Craig is Satoshi, and that was it. So the basis on which that judgment was made was all the evidence that was submitted from both sides. There were, as you mentioned before, there were questions about the partiality of the expert witnesses and all that. And then you've had people on, or you've mentioned about the Kristen Hansen thing, him supposedly being a bad actor.
Interfering, bad actor.
Yeah. But that's on the basis of I've got the judgment here. This judgment from May, 3rd of May this year.
Yeah, the judgment for Edgar Hansen, right? 3rd of May.
Yeah, the committal, I think it was, well, he wasn't in the country, so he was in default. The judgment went against him, but that was on the basis of Kristen Hansen not handing over stuff, documents and computers back to nChain when he quit, or he wasn't quit, when he was fired as CEO. So that's all that judgment is about. It's not about Kristen Hansen being a bad actor or spying on people or manipulating anyone else's documents. It's purely about basically a contractual issue. You know, employment contracts, usually at the end of your employment contract, however it ends, you have to give back the company's property. So, and he apparently didn't do that. So he got the judgment against him. But that's all that one's about. So I don't see how that's possibly relevant to any appeal.
Well, the only well, in an appeal, you can only rule basically identify the issues the court ruled on. So even so the reason I brought it up was because there are, I think it's like 40 different places in the actual ruling, and there's a specific ruling in there about him not being a bad actor. So the court did rule on that, and therefore it was ruled on. So it's a reviewable issue. It's an appealable issue. It may not win. I don't know, but it's an appealable issue. It was ruled on.
I think, and I'm not going to start going through the 231-page judgment, but there are a few places where Justice Mehl mentions Christian Og Hansen and him supposedly being a bad actor. But I should have dug this out, but I'm sure it says somewhere it's not even if he was a bad actor, the decision doesn't depend on that.
Oh yeah, because of other things.
So and if that's so, that in itself wouldn't be sufficient to overturn the judgment.
It wouldn't be the only grounds, right? It would only be partially one of the grounds. He'd need to show something else. I mean, and right now we're at conjecture, which is frustrating because I really want to know what the heck he wrote. What makes you think that he filed without an attorney?
Because I've been told by one of the respondents, by one of the defendants in the High Court case, who is now the respondent in the appeal, and the fact that just from what you can see on the public record, that there's a tweet that he put out that got me blocked. But there was a tweet.
He blocked you from his new account.
Yeah, it's the fourth time he's blocked.
He doesn't like Tufty the cat, huh? He doesn't like Tufty.
Well, let me go right back. I got into a conversation several years ago now, when he was using his, what was it, Prof Faustus?
Professor Faustus, yeah.
Years ago. I didn't really know much about him. He popped up and was talking about patents. And I forget what the issue was, but he said, here's a patent. And I just said, that's not a patent, that's an application. And it doesn't say what you say it says. And then we had a few back and forth. So I remember I was on the flight to Munich, just about to get on an airplane, and had a few back and forths. And then by the time I landed in Munich, I'd been blocked. So I thought, okay, what's that about? Oh, well, never mind. And then he blocked me again when he came back a few years later as whatever that Twitter handle was. And he blocked me on two different accounts, on my Tufty account and on my name account, which I hardly ever use. And then this latest one is on his new account. I responded, or I quoted him on this thing that he wrote on the 15th of August. He wrote, and bear with me because this seems really dry and very technical, but when in support of his claim to have filed an appeal, he said, and I quote, CPR Practice Direction 5A, paragraph 5.1, quote, a document which is filed electronically is to be treated as filed on the day on which it is recorded by the court as having been received by the court at the place where the proceedings are being conducted. So I thought, okay, that's interesting. So it sounds like he's done something himself. So I looked up, I mean, the Practice Direction 5A is online. All the civil procedure rules are online. So I looked that up, fairly easy to do. You just Google it. That Practice Direction, paragraph 5.1 says, the date on which a document was filed at court must be recorded on the document. This may be done by a seal or a receipt stamp. So I thought, that's odd. That doesn't say what he says. So why has he got there? And then he goes on to say another 3 tweets after that saying what this means. And I just commented, well, that's not what the actual rule says. And you've been very clear about which rule it was. practice direction 5A, paragraph 5.1. Okay, we can all look that up. And then what occurred to me then, I mean, I'm sure it occurred to lots of people, is that's exactly the sort of thing you get from ChatGPT.
What?
That's exactly the sort of response you get when you ask a question to ChatGPT. Because I've done exactly the same thing. Because I thought last year, I think there was a change in the rules on European Patent Convention. Doesn't matter what it was, but I thought, well, okay, I need to write a little article about this. I wonder if ChatGPT could help me, because everyone was buzzing about AI being really cool about summarizing things and preparing documents for you. So I just asked it something like, what's the effect of this rule change on the 10-day period under Rule 126 EPC, blah, blah, blah. And it came up with something that, on the face of it, looked completely plausible, with some explanation and everything. But, I know the European Patent Convention inside out, and immediately knew that was just not right at all. It's completely wrong, completely false. Sorry, I've got light on my...
Yeah, if you could fix that. Oh, thank you. I was going to ask you.
So it's a well-known thing in ChatGPT, especially, that it hallucinates.
Yeah, hallucinate. That's the word.
You ask it a very specific question about a very specific thing, and often it will come up with something that sounds plausible, but is 100% wrong. So my inference from what Craig Wright put up was that looks like something that you'd get out of ChatGPT. And I just to test that, I did, what sort of query would you put in to get that sort of response? You're asking it, I asked it, when is a document that is electronically filed treated as having been filed by the UK Court of Appeal? And it came up with something very plausible, but very wrong. So that was kind of confirmation that.
So it sounds like, for those trying to be their own attorney, don't use ChatGPT as your attorney, because you're going to get in big trouble.
Yes, absolutely not. So at that point, I'm pretty confident that he's done this himself.
Oh, no.
And he's used ChatGPT. If he can use that, if he's used it for just posting something on X, then most likely he's used it for generating all sorts of stuff. And the danger is that there was I remembered an news article from last year that I'd seen, just a brief one about some American lawyer that got into big trouble when they'd submitted some legal submissions on a court case, and the judge, in reviewing these submissions, saw that lots of the case law,
fake,
purportedly proper cited case law with all the italics and everything that you get. You have very long case law citations in the US.
Yeah.
But you know what I mean? They were all completely fake.
Fake, yeah.
These cases didn't exist. So a lot of these legal submissions were totally made up.
Yeah.
And these lawyers in big trouble, rightly so.
I saw that one. I think it was in New York. The guy put in all sorts of fake cases into the case, trying to argue his position. And
that's from the kind of thinking that, oh, ChatGPT has absorbed all this, and I can just ask it a question, and it'll come up with something. And oh, look, it's come up with something. Yeah, let's go with that, without checking. And that leads me on to the other thing that I mentioned that's very relevant to this case, which is that there was another article from earlier this year about an appeal judge in the Court of Appeal in the UK called Sir Colin Burse, who I've met a few times. He's a very nice guy, very intelligent, as all these appeal judges are. And he'd used ChatGPT to summarize something, and he put the output of ChatGPT in one of his judgments. But he only did that because he knew that it was correct. So he'd used it to. One way you can use ChatGPT is you ask it a question, and then if you believe the answer, you're a fool. But if you ask it to summarize a particular document, and you know what the summary should be, it can be quite useful. I mean, Colin Burse said this is jolly useful in his words, but the proviso is that you have to be sure that what it's produced is correct. So there's no way he'd put anything in his judgment that he wasn't 100% sure of. And my my strong suspicion is that Sir Colin is going to be the one that's going to see this appeal.
Oh, he's going to be the judge reviewing it, you think?
I'm not sure. I mean, that's just my suspicion. I mean, there aren't that many Court of Appeal judges in this area, but he's absolutely 100% bang on candidate for this one. So unless he's very busy doing something else, I think he'll be the one that does it. So it wouldn't be very good news for Craig, because this guy knows what he's talking about in terms of, he's used this technology, he knows the dangers, he will review the 561 pages, and he'll recognize hallucinations when he sees it.
So what is the next step? Well, first of all, can you tell us who the person is that you talked to on the side that has the confirmed he didn't have an attorney? Are you allowed to do that?
I could do, but I best not.
Okay. All right. So for the respect of that person, someone who's one of the defendants, apparently, so what is the next step? Like right now, we've got this notice, well, the application for appeal, and then now what? What's procedure? What's the next procedure?
Well, I think what happens next is that you have to wait until the court is back from recess, which is October probably. So they're off. They work on university term times effectively. So in the Michaelmas term, I think they use the same as Oxbridge terms. So in October, a judge will look at it and determine, possibly just on the papers, whether they will grant Craig Wright permission to appeal. They can request it. They can request a hearing, but it's not as of right, as you'd say. So Craig Wright doesn't have the right to have a hearing to decide on this permission to appeal. The judge can just rule on the papers, and that's it. And as far as I can tell, it just has to be one judge. So this is the bottleneck. It's at this point, it's go or no go. So if the judge goes, there's no realistic prospect of success on this one, that's it. End. If there is something arguable, then that will then go. It'll probably take a few months before that gets, and then there will be a hearing a few months later. Usually, Court of Appeal doesn't really hang around. They hear these things fairly quickly, within a few months. And then there will be a hearing in court, which will be live streamed, I'm sure. They hold these hearings on YouTube. Hardly anyone watches them because they're incredibly boring. They're really dry.
But if Craig Wright's going to be there, it's not going to be boring. That'll be a whole different story, right?
This will be different.
Especially if he's going to represent himself. He'd be up there arguing. Yeah. That would be cool. I would watch that for sure.
That would be interesting.
You might even go to that. That would be.
Well, we'll have to see.
Yeah, I mean, Craig Wright up there on the stand playing Perry Mason. I would definitely want to hear that.
Yeah. So one thing you said before is you were sort of making a guesstimate of how much it's cost Craig to prepare this appeal.
Well, in thinking that he was hiring one of those law firms, I was right. I mean, what would you say? Well, we can't rule that out. I mean, I have not seen proof. It's all hearsay right now. I don't even know who you're talking about. So we don't know for sure definitively if he doesn't have a law firm involved, right? So we don't know. We believe so.
We know it's not Shoesmiths.
Okay.
Because they've said they haven't been instructed. We don't know who else it could be, if it is anyone else. So yeah, it's all hearsay, but it certainly everything points towards Craig Wright doing it himself. Well, he's a lawyer. He claims to be a lawyer. He's got an LLM from, where was it? Northumbria University or something. I don't know. I can't remember. It was one of those in the UK or Australia. But anyway, claims to have an LLM. So yeah, of course he can do it himself.
So what's the, what would you say I made a prediction about the cost that he would potentially be spending, I mean, on all this. I mean, what do you think, how accurate that would be for such a
I,
big
I think
case?
I think it'd be difficult to get it up to 1 million. I think that was your rough estimate,
But
but
yeah.
it will be, tens, maybe getting into hundreds of thousands if you had a big team of lawyers working for you. I don't know. I don't move in those circles. It's way above my pay grade.
Yeah. Well, it seems like, all right. Well, all right. Well, now could be a good time to shift over to like the effect of this, because you're heavily involved in reviewing all the nChain patents, the nChain stuff, and you overturned one patent so far, right? Is that the correct analogy? You guys have overturned one, or is there, and
It
there's
was a
more
it,
pending?
yeah, that was a bit of an odd one, because I filed it for, well, Arthur filed it, I wrote it, Arthur Van Pelt. Um, it was basically just a test because I saw this one and immediately realized this is not going to survive. Um, and I talked to several other patent attorneys and showed them, and within 5 to 10 minutes, they all said, "Yeah, this is dead." So it was one of those things. I won't get into the details, but there's certain things that you do that you absolutely shouldn't do, that would make the resulting patent invalid, irrecoverably invalid. That was the key. So I thought this would be a nice test opposition, uh, for the benefit of Arthur or for the benefit of a bit of publicity and to get people knowing a bit more about nChain's patents because there are lots of them. Um, and then what happened was that these things take about 18 months from start to finish. So you file the opposition, then you get a few months, and the proprietor gets a chance to file their response, which they did, and then you have to wait a few months more, and then the opposition division at the European Patent Office, um, normally issue a preliminary opinion. So still on the papers, and they issue, along with that, they issue a summons to oral proceedings. So the oral proceedings were going to be held in beginning of July, and in advance of that, you usually get a couple of months before that oral proceedings, you get the last chance to file arguments and amendments. And then at the last minute, just before this final deadline, the attorneys got switched. So the attorneys were switched from firm of patent attorneys called Murgatroyd, who had handled it right from the beginning, and it switched to another one called Gill Jennings Avery. And when I saw that, I thought, oh, maybe they're taking this seriously and bringing in the big guns, and these guys know what they're doing. And then basically the following day or a few days after, they just pulled it. So they just went, we give up. We throw in the towel. We want it revoked. So they didn't want to go through the argument at the oral proceedings, for whatever reason. They saw that it wasn't going to survive, which, to be honest, is a sensible move. I've never seen that before on any other case, but I had to do a bit of research on the case law on that. And yes, of course, they can do that. And if you don't want to go any further, you can revoke your own patents, and that's what they did. So that one went, and then we've got two others which are still pending. They were less certain, so they didn't have this central flaw in the patents, but they were in the same family. So there were three patents in the same family. Basically, they originate from the same filings back in 2016, that were filed in the UK, and then these worked through the system and ended up at the European Patent Office. One of them got knocked out. The other two still there. And only a few weeks ago, the new attorneys filed their responses, and they filed, in one case, 15 requests. So they're trying to have 15 shots at if this doesn't work, then this, and then this, and then this. So if we have to go through all 15 on the day, and it's towards the end of September, the hearing is, then that will take quite a while. And on the other one, I think they've got 18. So they're throwing lots of stuff at it.
They're opposing it, you're saying,
They
vigorously.
are defending.
They're
So
defending it vigorously.
they're not
Got it.
they're not giving in. They're not throwing in the towel. They've actually put something together and put some.
Is this are you allowed to say who you're opposing right now? Who the representative is? Is that
Well,
somebody at nChain?
it's all on the public record. So again, it was the same. So Murgatroyd's initially represented them, and then they switched to Gill Jennings Ebery. Another both reputable firms of patent attorneys.
So they're outsourcing. They're not using their own in-house counsel. They're outsourcing.
No, they don't do that anyway. They don't do anything in-house on their patents. It's all outsourced to
Other firms.
Outsourced firms. But they only use two in the main for their European patent work. So there's Murgatroyd's and there's Page White Farrer. And I don't think I'm breaching anybody's conference,
So
but
are you allowed? Are you allowed to comment about Mr. Belzen at nChain? Do you know him?
I don't know him at all. I know his name. He's the one that pops up when you search for someone who's a patent attorney at nChain. He's a European patent attorney. He's based in Switzerland. I'm sure he's a fine patent attorney. I don't know anything more about him than that.
Okay. So I want to ask you about like the effect. Okay, let's say that you were now this is just totally I'm going to give you a little disclaimer. Okay, let's just go into imagination and fun here. I know you're an attorney, so you're not allowed to say a lot of stuff, but let's just say you were COPA or you were representing COPA, and they hired you in an imaginary world off the totally what would you, how would you be a strategize? What a possible strategy. Now, this is for the people supporting Craig Wright and BSV. Please brace yourself because this is not going to sound, this may hurt. All right. So but I want to get it on the record for how possible strategy is going. Would your possible strategy as a COPA attorney be to attack Craig Wright for the identity issue and then to attack the patents if that's successful on the credibility of the patents, saying that they were built by someone who lied? I mean, have you thought about this at all, or can you humor me here and how it could put? Yeah.
I mean, it's one of the things that keeps popping up when people comment on usually on Twitter X that they say, well, all these patents are fraudulent because Craig Wright isn't Satoshi. And my response is, well, it's kind of irrelevant. It doesn't matter. I mean, the patents are separate. And this is what nChain would say as well, that the patents are a separate path entirely. And it doesn't matter to the large extent, it doesn't matter who was the inventor. They stand by themselves. So it's not a ground to revoke a patent, at least in Europe. When there are complications in the US, perhaps, but I'm not a US attorney, so I'm not going to go into that. But it isn't a ground to revoke a patent on the inventor pretending to be someone he isn't. It's just not relevant. It's just the invention is what it is. It will stand or fall mostly on the basis of whether it's new and inventive and industrially applicable and all the usual rules. So yeah, I mean, it's not sorry. So, it's a good news for the BSV crowd.
I'm surprised. So you're saying that if you were representing COPA and they said, hey, let's go after some of these patents based upon the fact that Craig Wright wrote them and he was a fraud, according to the court, you would say, I don't know if that's such a good idea. You're saying?
But there's nothing to go on. All you can go on are the grounds of opposition. In the European Patent Convention, you've only got three possibilities for opposing a patent. One, that it's not patentable, so it's not novel or not inventive, or possibly not an invention that's allowed to be patented, or it's insufficiently disclosed, so it claims something that's impossible, or it's at some point it's added matter. So an amendment has been made that isn't based on the original filing, and that's all you've got. There isn't a ground of the inventor wasn't the real Satoshi. the inventor is or even if the inventor is not the right inventor, that's not grounds for revoking a patent.
So I mean,
In the UK, you can apply for the patent to be assigned to someone else if the inventor wasn't the real inventor. But again, this isn't the situation here. It's slightly different in the US, where if the only thing that might possibly be relevant is if an inventor was not an inventor. That can result in a patent being, I can't remember whether it's revoked or unenforceable, but the effect is the same. And I haven't looked in detail, but there are quite a few cases where Craig Wright has been added. This came up in the court case under Jonathan Moss's questions to Carry On Jones. He raised the issue of there being 60 applications where Craig Wright had been added as late as 3 years after the application was filed. So the original application named an inventor or more than one inventor. Craig Wright was added in 2 or 3 years later. That doesn't sound particularly above board. So if that had happened in the US, that could be difficult. That could raise difficulties.
So, COPA is a crypto open patent alliance. So they want open patents for all, right? All the blockchain spaces eventually. And so, I mean, what does COPA want? Because they were created to crypto open patent alliance.
Well, they work more. They're not, so far, they've not been in the business of knocking out other people's patents. That's not what they were set up for. They were set up as and I'm not clear on how this works in practice, but I can explain how they explain it, which is that you have members of it's almost like a patent pool. So if you join COPA, you pledge not to use your patents in a sort of patent troll way. So you don't go after people. You're only going to use your patents in a defensive way. So what the idea behind COPA is that they'll gather all these members with all their patents, and they will, kind of like how NATO works, I suppose. If someone comes along and attacks one of their members, then all of them will pile in and attack them back with their patents. So it's only to be used defensively. So if, for example, nChain starts suing people, and one of the people they start suing is a COPA member, then other COPA members will be asked to provide patents that they have that nChain will be infringing. So they'll countersue the people who are suing a COPA member. So it's not the way that it would work, as far as I understand, is not that they would proactively try and knock out nChain or whoever else's patents, but they would wait for someone to be sued first, and then use their patents defensively. I suppose it's a form of negotiation. So if nChain say you infringe our patents, then COPA member pops up and says, you infringe our patents. So what are you going to do about it? And that's common, and that's why.
That's so common in the US for litigation. That will, at least not in patents. I don't know about that, but that's very common.
So it's a bit different to a patent pool, where something like the probably the most famous one is the CD pool from would have been early 1980s that was set up, and the same thing was done with DVDs, where you had companies like Philips and Sony were the primary developers of the technology, and then they didn't want to get into fights with each other. So what they do is, along with any other companies that had developed useful bits of the technology that all needed to go into a CD player, they would then pool all those patents together, and then using an arm's length, otherwise it would be, so it isn't a cartel, using an arm's length organization, that organization would then issue licenses for anyone who wanted to come along and pay the license fee and make CD players or CDs. So that's different. So that the patent pool is different. This is it's not a pool, it's a defensive pool of patents that would only be used if one of the members is attacked.
All right, well, that clears up that. I was improper on thinking that their strategy was to invalidate Craig Wright as Satoshi and then attack the patents. Or, I mean, it wasn't really, I was just theorizing, and I think other people had thought about it. I thought that was you're saying that's pretty much not even possible with the way the patents work in the UK. It's just not a relevant ground.
They can do that if they want, but I haven't heard any noises to that effect. I mean, there may well be things going on behind the scenes that I'm not privy to, but I'm not aware of any of that going on.
So nChain, they filed a lot of patents and they were granted a lot of patents. In the UK, when you get granted a patent, how much scrutiny does the UK go to on that patent when it's granted? How much scrutiny goes into that, if any?
Well, they test for the same things that they do at the European Patent Office. So that all of these patents, actually no, some of them they've got through the UK office. Most of them they've got through the European Patent Office. The way the system works in Europe is that you have the European Patent Office will grant a patent. So they've got examiners who are very knowledgeable in specific technical fields. They will examine the application. They will test it against all the rules and articles that they have to apply. They will raise objections on the usual novelty, inventive step, added matter, blah blah blah. And once the applicant has satisfied the examiner that they've overcome all those objections, so usually you have to amend and argue your case, then the examiner will take it to an examining division. So there's 3 examiners have to decide together that the patent is okay to be allowed. Then it gets granted, and then the same patent is then in force in up to, now I forget the number, it's 34 plus countries around Europe. It sort of becomes this, it divides up into a number of different patents across Europe. So it's not the European Union, it's the European Union plus a few. And now we've got the added complication of the unitary patent. So there's a subset of EU countries where there's a single patent granted by the European Patent Office that's the same throughout all these unitary patent states. So France,
All
Germany,
right, so when they grant them, they do go through a very rigorous process. They don't just rubber stamp the patents. It's very rigorous.
It's pretty rigorous. I mean, that's my job. It's often, most times it's quite hard to get
okay, that's a good answer. So in simple terms, it's hard to get the patent approved. And so it sounds like nChain has had about, how many has nChain had approved? Do you have any idea? Including all the patents under the nChain umbrella, like the ones under different names or whatever. Do you have it?
I should have this open. Let me.
I think those are the ones that are really applied for patents. We don't know what's going to happen with, right? They could be invalid. We don't know. So, but the approved ones, it sounds like they've gone through a very rigorous process. I'm wondering.
They've got at the last time I checked, they've got 120 European patents granted.
120. All right. Now let me ask you. Go ahead but yeah, if you want to add to it, but I have a question about that.
Yeah, there's 120 granted. They've got 25 that have been allowed. So there's a process where the examining division says, okay, this is the form of the application that we're willing to allow.
Is that preliminary or after?
Before it gets granted.
Okay.
And then the applicant then gets the opportunity to approve that allowance, pay the fee. Maybe sometimes, and nChain do this a lot, submit some minor amendments. So if you spot there's a error somewhere.
So 120 granted, and then another 25 allowed.
25 allowed. So the expectation will be they're going to get granted in the next few months, and then another 423 that are still pending.
Okay, now
big pile.
That's a big pile. How much money do you think that costs to do all that? I guess maybe one at a time. I mean, any idea?
Well, each one has already been through the UK. So in the ones that we're opposing, so they were first filed in the UK in early 2016. They then went through the international system, which is another sort of temporary holding pen for, don't need to go into the details. And then after that process, it goes through to the European, US, China, Japan, wherever else you want to go. So it sort of starts with one filing in the UK, becomes one filing internationally, and then balloons out into maybe 8, 10 different patent applications throughout the world.
Other jurisdictions.
Each one, and at each point, the costs will go up. So the initial filing might be, I don't know, rough ballpark 10 grand, say. Then the international one might be another 5 to 10 grand, probably towards the lower end. And then the all the national filings, and this is 2 or 3 years after the initial GB one, each one of those national filings will then cost another 5 to 10 grand each, just to get it into the system.
I'm not.
And then,
wow.
And then each one of those will have to be prosecuted. So then you've got the extra costs of back and forth with the examiner, and that's where the costs can. It could be easy, and you get an easy ride, and it goes straight through to allowance, and then there's not much extra costs, or you might go back and forth.
So like 50 grand total per patent, or less than that?
Ballpark, yeah, something
okay,
like that.
Ballpark. Let's just say ballpark, right? So, and that's with attorney's fees?
Yeah, official fees and attorney's fees, yeah.
Okay. At 4, and you said at 125 plus 25, that's 150 plus 400, how many? So you got 125 plus 25. So
you can do rough back of an envelope calculation and get into several million easily.
Okay, it's a lot of money. My point is that all right, so they've done that. Now, let me just explain the theory that I believe is behind nChain. I really challenged the guys at nChain to come forward and explain this theory, okay, but they haven't. But the theory is that, that I understand it, and I want you to please comment on this as well, that if you use the BSV blockchain, we'll allow you to use that, and you're not going to be infringing on our patents. If you use a different blockchain, you could be infringing on our patents, and we might sue you for that. So, and is that simple terms? Please explain, how you understand it or how it is legally
well, that would be the license terms for using BSV.
Okay.
So I haven't seen the license, but I would guess, that sounds right, more or less right to me. So if you are licensed to use BSV for whatever use, then that would have to come with a license under the patents. Maybe according to which jurisdiction you're working in, because patents are different. They're specific to jurisdictions. So it will be very different to the Bitcoin license, which is just the MIT license. So you're free to use that as long as you keep this notice up saying, you're free to do whatever you want with the Bitcoin BTC under the MIT license. That doesn't mean you're not going to be infringing someone else's patent if they've got a patent for something that has been developed on Bitcoin. And I think that's the, I'm sidetracking a bit, but that's the potential danger on the BTC side. So if it turns out that nChain have managed to patent something that has been developed on BTC, then there could be an issue. But if you're using BSV, my assumption would be that you'd have a license under the patents to do whatever you want to do, and there must be some money involved. Otherwise,
Now, all that seems good for BSV. So, can you please give me the opposition? Because obviously, you're an expert in patents. I mean, what do you think is going on? Are the patents frivolous? I mean, why don't you? I understand you don't support BSV, right? So at least that's your position. So clearly, you see there's a hole or a flaw in this whole theory. What is your?
There isn't necessarily a hole. I'm not a business advisor. People are free to get patents for whatever they want, and if there's a business model for BSV, and the patents support that, so that effectively it prevents other chains being set up that compete with BSV, then that's okay. That sounds like a business model. It's just a question of why would you need so many? Because it's very expensive. And so you've got to justify the large costs in getting all these patents by license fees, I guess. But I don't see what other sort of revenue are you going to get? It will need to be license fees or on-chain fees, mining fees that the miners on BSV are, I think, mostly owned by whoever owns BSV. I'm not going to mention the name.
All right. So what problems are there that you're seeing? I mean, clearly I'm just seeing I honestly want to understand like the problem with BSV, and other than Craig Wright being a fraud, that's already been determined, right? So I'm sorry, not being a fraud. That's actually not fair to say. He was just determined not to be Satoshi. That's unfair to say that. And I think it wasn't determined. So that is.
I think we can safely say he's a fraud as well, because that was part of the judgment.
Okay. Well,
forgeries.
So are there any other grounds like that? Let's say that, that you would say, well, this whole theory behind nChain and the BSV is flawed. It's not going to go anywhere. I mean, what is
that? If it was only about that, then everyone else could just go, okay, well, we don't think BSV is viable, so we're not going to use it, and we're fine. The problems only started when Craig Wright started suing people, and then it turned into eventually 5 years later. I think it took about 5 years from when Hodlonaut got sued, and then the result of the COPA and Wright judgment should draw a line under all that. And now, once this is all finished, we can all just, the people who aren't interested in BSV can just go, okay, well, we can ignore it. If BSV can be a success on its own terms, then fine, you go ahead. It shouldn't bother anyone else. If it can be a success, then great. Carry on.
I guess do the other let's say BTC, does BTC have any risks of being in any patent infringement from BSV?
I'm not aware of there being any realistic threats of infringement. I know I've seen several times where Craig Wright has popped up and said such and such infringes on a patent that nChain have got. He's thrown various threats around to Ethereum and some other bits, as well as Bitcoin. I'm not sure if he might have said something about Lightning. Yes, he's definitely said something about Lightning infringing one of his patents. And I did look into that and decided, yeah, it probably doesn't. So that's the danger really, is if the danger from the BTC side is if nChain start suing people using their patents on the basis that something implemented on BTC Bitcoin infringes one of their patents, then that's gonna cause a problem. But nothing of that type has happened yet.
Are you concerned about that happening? If, let's say, you were a BTC investor, and I don't know if you are, but let's say if you were, would you be concerned about that?
It's impossible to tell, because there are 500, nearly 600 inventions working their way through the system. It's impossible for one person to go through all of them and analyze them and do a freedom to operate on, is Bitcoin clear of all these? And things happen when patents are being prosecuted. People end up getting more than they should have got from that initial filing. And to go back to the oppositions, that is the case from my point of view. That is the case with these remaining two patents. They claim something that was known before 2016. That now there's no suggestion that nChain is is suing anyone or threatening to sue anyone on the basis of these patents or their equivalents in America, China, Japan, or wherever else they are. But if they've got a patent for something that was in Bitcoin before 2016, that for a start, it's invalid, and but for another thing, it's a potential threat. It can cause lots of problems if people start suing based on these invalid patents, and that's not what Bitcoin BTC wants.
And so are those, is that the grounds that you're suing, suing to overturn the two patents on right now, that they were prior inventions?
The first one, it didn't matter because it wasn't a prior art issue, although there were prior art arguments. But the killer argument was an amendment had been made that wasn't allowed, and it made it invalid. But on the other two,
we see your CGI, so there you go, off into the distance. Up, gotcha.
I'll put it there so you can see it.
Mastering Bitcoin.
Mastering Bitcoin by Andreas Antonopoulos from 2014 is basically a brilliant prior art Bible for this is what Bitcoin was in 2014 in some technical detail. So it's a very good sort of stake in the ground of this is where it was at that time, and that's effectively what I've used on these oppositions. And it's a matter of, in some senses it's semantics. I don't want to go into the detail because I might give away the arguments that I've got for next month. But if you interpret the words broadly in the patent claim, you can cover something that was in the prior art. And then the patentee will go, no, it's not supposed to be that broad. It's supposed to be very narrow, and then it doesn't get covered by the prior art. So okay, we have an argument, and then in the end, the patent survives, or it's amended, or it gets revoked.
Nice. Okay. All right. So we got about 5 minutes left. So I saw that there might be some questions that some people on your feed had asked, and so I want to find out if there were any that you had. Specifically, one I keep getting is Craig Wright going to jail. That's one that I keep getting. So maybe you want to comment on that, and then any others that you see.
Well, on that one, I think the chances of him going to jail are looking less likely.
Less likely.
Yeah, because the Crown Prosecution Service is so busy at the moment, so he's probably going to be waiting quite a while, and they're sending lots of people to jail, but people that have been saying rude things on Facebook, or people that have been threatening rioting in the. I don't know if you've been following what's going on in the UK. The CPS under Keir Starmer has said to the CPS, "I want you to clear your desks and prosecute all these people." So they're busy at the moment. So I think Craig can is safe for a while yet, and it depends to some extent how full the prisons are when they get round to looking at it. So it's ridiculous. It shouldn't be a factor, because it should be, what crime have you committed? How serious is it? Should you go to jail for it? But there are other factors, so that may well come into play. I'm less confident that he will go to jail. I think he should, but I'm less confident that he will.
All right, fair enough. How about some of these other questions?
Well, I mean, I'm reluctant to. I mean, this is you interviewing me, so it's not me asking you difficult questions. But one that came up a few times is you seem to be a BSV supporter in the main. Why?
Well, I try to remain pretty subjective on here, but at the same time, I think we gone through a lot of the questions here that I was trying to flush out, like today in this show. So I guess in closing, I would say, I'm looking for flaws in the legal argument behind BSV, holes in the whole patent structure. I'm open to being told that there's a huge flaw here. There's a huge hole. This is. So I just haven't, other than the Craig Wright thing about, that obviously is the big red herring. But now I was expecting to get the news today that, now COPA is going to go and try to overturn all these patents because Craig Wright's not Satoshi. I thought that you were going to say that. I'm surprised. I'm shocked that you.
Okay. Well,
I'm honestly shocked.
they might do, but they haven't told me.
But you said they don't even have the legal grounds. That's not even that's not even I mean, it's a poor argument, So
Well, it wouldn't it wouldn't run.
it wouldn't
It's
work.
not an argument.
Not even an argument at all.
No, no.
Okay.
Yeah, I think we covered most of the things that, other than some of the silly comments. Oh, oh, okay. Well, maybe we need to, if we've got time, the accusations that have been laid against me and Mr. Justice Mehl.
Oh, yeah. Thank you about up. There was accusations about you guys co-conspiring together. Please comment. So, from what I read, that was on the last video you had said you went out. Well, you guys had dinner together. Then you saw him at another conference, and he commented on the BTC stuff. So, please summarize and respond. Yeah.
So the basics. So I've been. Can we go in a few more minutes, maybe?
This is important. Yeah, we'll go on a couple more minutes. I want you to, I want to hear your response because it's been pretty vigorous on that. I have seen
this Tufty the Cat pseudonym I've been using. I've been using that since 2008, I think. And I did it while I was a trainee patent attorney. I wanted to comment on a referral to the Enlarged Board of Appeal at the European Patent Office because it was on an area that I was interested in on software patents, which is a big thing at the time. So I did some legal research and analysed the questions that were raised to the enlarged board, and I thought I don't want to put my name to this. I just want the comments to be submitted, and then the legal arguments should stand by themselves. And I'd started using this Tufty the Cat pseudonym. I think I initially used it on the IPCat blog, which is well known in IP world, in relation to a patent for a bird table, a ridiculous thing. But so I filed these submissions in 2008, 2009, I think it was, under this Tufty Silvestris name. And the funny thing about that is that I had to sign it. It got bounced back. I said, you haven't signed it. I thought, how can I sign it as a cat? So I signed the letter Tufty Silvestris, put a little paw print. And then, I mean, if you want to do a bit of digging, you can still find that on the EPO website. So there's these legal submissions in the name of my cat, who was then still alive. It is a real cat. Died in 2012. And then there were lots of people that were going around going, who's this Tufty the Cat? Because I hadn't announced that it was me. And then I found out someone emailed me from Australia saying, do you know Lord Hoffman's been putting a picture of your cat up on his presentations? Lord Hoffman is like very senior House of Lords judge from long way back. He's like the top of the judges in the UK, and he'd been citing my comments on this software patent issue. I thought, blimey, this is a bit much. And then I eventually met him when he came to Birmingham and did the same talk. So I doxed myself to the first person publicly to find out I was Tufty the Cat was none other than Lord Hoffman in 2009. So ever since then, I've been posting as Tufty the Cat, mostly on blogs and then later on Twitter and X. And as part of my work, day-to-day work, I'm part of this European program organization called Union IP. And we have these meetings and we meet judges, and we usually meet in Munich, and we get judges to come along and talk about patent law. So I've met over the last 10 years or so, I've met a lot of the IP judges from the UK. I've met Colin Burse a few times. I've met Robin Jacob, Sir Robin Jacob, who's retired now, but he's another great Court of Appeal judge. And I met Sir James Mehl because he came onto one of these Union IP seminars last year, and the person who invited him couldn't come to the dinner, so he asked me whether I could take him along. So I got the job of taking him to dinner. So we had a dinner and we chatted about stuff, and he told me at the time that he just been given these four separate cases involving Craig Wright. So I immediately went, okay, we better not talk about Craig Wright then, because being quite aware that this will be, I don't want to prejudge anything here. So we chatted about Bitcoin, but didn't chat about Craig Wright. Chatted about database rights, which is a world expert on. So that was, had a nice dinner. He did the seminar on, I forget what it was, some amendments to do with patents the day after. Went very well. And then he remembered me when I went to this seminar a couple of months ago, when just before the judgment came out, and he just had a little chat. Then it was a seminar with about 100 other patent attorneys, and this is just the sort of thing that happens in the profession. The profession is quite small, so there are only a few thousand patent attorneys, and only a few that are really interested in the case law, like me. And then there's a small number of IP barristers, even a smaller profession. And they all know each other. All the judges and all the barristers know each other, all the patent attorneys, all the litigators, they all know each other. They go to these things all the time. So the only difference is that I mentioned it. That's all. Usually people keep these things quiet, but I'm not a party to the case. I'm not party to this Craig Wright case. I threw in a few comments here and there. The barristers picked up on a few things that I said, but I've had no influence on that case whatsoever. And I'm sure if you ask Sir James Miller himself, he would be, I'm not sure he'd be angry. He'd probably be bemused of the suggestion that he might be corrupted by this lowly patent attorney who's just being nice and having a chat. It's just ridiculous. So when okay, it's libelous. It's definitely libelous, accusing me of corrupting a judge. But so what? It's not a big deal. It's just really silly. Really silly.
Well, thank you for clearing that up. It's great to get your response. Very important, and to hear what you have to say. And it sure would be great to hear what Justice James Miller has to say about this. I would love to get him on a show. I don't know if he's allowed to do that, but
Judges they're all very nice people, and they do presentations at seminars and things. But I don't think I've ever seen one do a podcast or anything on YouTube. I doubt you'd manage to get him on.
They mentioned me in the court case, so maybe he knows who I am. So one of the witnesses said he was watching my shows. Yeah.
Oh, right. Okay.
Yeah. So one of the witnesses testified. They said, "Have you heard anything about this case?" He said, "Yeah, I've been watching this guy Gavin Mehl's show on YouTube about this case." He says, "Oh, okay, all right. Well, noted. That just don't call." I don't know what the court said, but something like, "Okay, noted."
Right.
Yeah.
Oh yeah, he's got a phenomenal memory. He'll probably remember the name. So
you would remember that. So nice. All right, David. Well, it's great to see you. It's awesome to get all this stuff about nChain and your perspective and the Craig Wright case. It's super, super phenomenal. I'm planning on doing another trip out there to London in probably May of next year. So I don't know what day, but yeah, hopefully we can connect up there and have coffee and see how this whole thing plays out. But yeah, if there's any big news, let's talk again. I mean, there's going to be news on this coming up, so let's keep our eyes on it. So I definitely want to hear your perspective.
Before next May, sometime in the next few months, I would guess.
Yeah. So once we have some news, let's do another show and we'll connect and see what see how it plays out.
Okay.
All right. Thank you, David. I'll go ahead and end the recording there. I'll see you at the top. See you at the top, everyone. Thanks for watching. Be sure to subscribe and like, comment.